the trial captivating a nation.
John O'Keefe's niece testified. The juvenile recalled Read and O'Keefe fighting in the weeks leading up to the Boston police officer's death.
There was a trip to Aruba where Karen Read accused O'Keefe of kissing another woman, and there was a big argument. She said that things got progressively worse after that. There was a lot of fighting, a lot of voice raising.
The prosecution is trying to establish the fact that there was tenseness between John O'Keefe and Karen Read.
NBC 10 News has the latest on the retrial of Karen Read.
That's right. We do it in this debrief every day after 5 o'clock when court is over. I'm Gene Valicenti. NBC 10's Katie Benoit is joining me. Let's begin with Karen Read. We just caught up with her outside court. She wasn't very talkative today. She had plenty to say yesterday, not so much today, as her side began cross-examining the state's last witness, the accident reconstruction expert. Let's listen outside court. Karen Read.
Karen, does the defense want to call Trooper Paul?
I don't have any comment. Thank you.
24 miles an hour, Karen?
Thank you.
Okay, so nothing from Karen today. Court resumes again tomorrow. Let's get to the action today. Dr. Judson Welcher is an accident reconstruction expert with the company Aperture. The state called him. He gave his version of what he thinks happened. He reenacted it yesterday. Today, there was a ruling on whether or not he can say an accident happened or he suspects an accident happened. Katie Benoit up there for us every day. What was the ruling, and give us the lead up to the significance of that?
Sure. So yesterday, when court ended, there were some objections by the defense about what Dr. Judson Welcher was saying. He was saying a crash happened. So the defense didn't want him to tell the jury this. There was a hearing yesterday on it, and today the judge issued her ruling. And she said that Dr. Welcher could say that the damage was consistent with a collision. He could say that the injuries to John O'Keefe were consistent with being hit by an SUV, but he was not allowed to say that it did happen. There was a crash. So that was the ruling today.
Yeah, because there's no eyewitness to that. There's no videotape to definitively say an accident happened. So I see the significance. This is the judge's ruling. Go ahead and roll that.
Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Read's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Read's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Read's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling.
Okay, that's the ruling. I think we follow it. He can say, look, I believe, looking at his injuries, looking at the car, that he was hit by a Lexus. And he can get specific as to the type of Lexus, but he can't say that her Lexus hit him. Am I getting this right, Katie?
So he was able to say a Lexus. So remember, the Commonwealth actually got a Lexus to do some testing with. The company that this crash reconstruction expert works for bought a Lexus that will eventually be paid for by the Commonwealth when it goes to get sold. You'll see that in my package tonight. But yes, so he was able to say that it was consistent, his injuries with being hit by a Lexus.
by a Lexus. Okay, and he was hit, according to the state, in the area of the tail light. The tail light is broken. The pieces are on the ground. Police recover them. We have a soundbite with Dr. Welcher talking about the broken tail light. Go ahead and set that up for us.
So the broken taillight, there was some testing done yesterday that was shown in the courtroom about kind of the blue paint and the car backing into Dr. Welcher. He did some testing on his own, a couple miles an hour. So there was some testing done to see kind of what that would look like if someone's arm hit the taillight. And there's been some questions again of where those injuries came from. Did they come from the taillight? Did they come from a dog attack? Yeah. So he answered some questions on cross-examination about that today as well.
Right. He used himself to play the role of John O'Keefe. And when the car backed into him, it was only moving, I think, 2.2 miles an hour. In reality, both sides, there's no dispute that it was moving close to 24 miles an hour. Okay, let's listen to this soundbite. This soundbite about the broken taillight from Dr. Welcher.
Opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with a collision as long as it's greater than approximately 8 miles an hour.
Okay. Katie, just remind us, that was the state's voice, the prosecutor leading the questioning of that particular clip?
Yes. So Hank Brennan this morning finished up his direct examination before cross-examination started. It was pretty quick. So the majority of the day, Welcher was on the stand answering questions from the defense today.
Okay, then cross-examination comes, and we're going to lead into this soundbite. Tense exchange with Dr. Welcher and the lawyer for Karen Read. What was the tense exchange about? And then we'll play it.
Sure. So Bob Alessi was doing the cross-examination today, and there were some tense moments in the courtroom asking questions. At one point, they were talking over each other a little bit, and the judge had to stop them. And this was in regards to broken bones. In the medical examiner's report, there's no notation of broken bones on John O'Keefe's arm or hand. And the witness was saying, well, there were no x-rays done, so that can't be known for sure. So I didn't see any broken bones in the autopsy report. So this was kind of this exchange getting a little bit intense in the courtroom today.
Yeah. Well, let's listen to it. Go ahead and roll that.
The position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I need to use proof in my question.
Ask me about the opinion of a medical examiner. I'm not a medical.
Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for Madam
I
Court
understand,
reporter.
and I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
You know what? Let's hold it there. Let's hold it there. I wish that everybody had a microphone on. It'd be easier for us to follow. But I think we get the gist, and that was just to show that there was tense cross-examination today. And the witness is basically saying, I'm an engineer, I'm an accident reconstructionist, I'm not a medical examiner, I'm not a doctor, you're asking me things outside my scope. Katie, how did this witness do overall? What's the consensus? How did he do? Did he help or hurt the case?
So the cross-examination today seemed very long. At one point, I kind of looked over and noticed the jury seemed to be getting a bit tired.
Yeah.
Court wrapped up around 3:45 today, but there was a lot of angles he was asking about. So it was kind of tough to follow. And I imagine the jury was having a tough time following it as well. But yesterday, there was some evidence he presented from Karen Read's SUV about, a backup event happening at 24 miles per hour, give or take. So some of his testimony, I think, definitely was hurtful to the defense. But there's a whole nother day of cross-examination as well happening tomorrow. So it'll be a long cross. So there's many points that the defense will be able to bring up to this witness.
Right. And did I hear the judge say it's a nightmare for them? Was she talking about the jury?
She was talking about the court reporter. So there's a woman who she kind of has a mask on and she's repeating everything. So it's hard for her to follow when people start talking over each other.
Okay. Yeah. Okay. All right.
And there were some questions too about credibility of the report, because this crash reconstruction expert works for the same company as Shannon Burgess. They work together. So there were some questions about his report earlier a couple weeks ago when he testified, and changes to PowerPoints that Dr. Welcher did kind of last minute. So those were some questioning that happened from the defense, some lines of questioning about credibility.
Okay. He's back on the stand tomorrow. At some point, when Karen Read presents her case, she's going to call her own accident reconstruction experts who are going to give their version of events. In the meantime, I'll let you go to work. We'll look for your reporting a little later. And I'm Gene Valicenti in the NBC 10 newsroom. Concluding today's daily debrief. We'll see you again tomorrow.
The trial captivating a nation.
Talking about when those taillight pieces were found.
Video was played for the jury of Karen Read's SUV in a secure area at the Canton Police Department. The car arrived a little before the first piece of broken taillight was found at the scene.
The defense alleges evidence might have been planted.
Proctor was seen on camera near Read's broken taillight.
This unequivocally shows that Michael Proctor walked toward the right rear area of that SUV.
NBC 10 News has the latest on the retrial of Karen Read.